Minority leader in parliament Afenyo Markin said neya sheshe why press conference na said judge na otna Kpandai constituency assembly so no said was here to be a man and nyasem gito at a point meet press conference gonna be yamushime because who ni say and try as a one nullified the entire constituency election for the parliamentary bit no and to see ameno say minority leader no Afenyo Markin make you one or two demands be the whole some ebro right here on Nana Jantuati. But assembly by no Tanko computer or no any deputy director in charge of NDC election or no swakasa afa the judgment from the Tamale High Court and so and a parliamentary candidate no representing NDC Daniel Nsala Wakpal or also Ekasaye or say 88 MPP for Mopekwa Mamon contested. I Tanko computer some Mopekwa MPP for Mamon contested sa election because dia omo NDC ebe wini ye be dwan seminum edi ama share Nana Janto TV mpacho oba click subscribe button ama me see we have bell notification icon you just turn it on so that be a video need drop here you be the first person to get it as usual video no be enjoy party what you make of it you like here no leave you comment in the comment section I feel we are oba share for front so anya bi ahwe me dey the Stephen Zando yemu ansem 3 days ago, and I bet you as Tamale High Court presided by Justice Emmanuel Brew plunge and the judgment in above on the issue of NDC parliamentary candidate in Kpandai constituency Daniel Nsala Wakpal Eriko PM court no Tamale High Court had the decision by say we are nullify sa election results no parliamentary results no nyina entino we order say 30 days yanko fresh polls na sansa ni beto dwano NDC for and some to just say I mean kunimdie ema omo because you fresh post now their confidence on be winning but na as MPP the normal the monster attack kakra enne minority leader in parliament Afenyo Markin wa be press conference chenchirenche so antiase na election ye kwaye no polling stations ni nyina krampo na yanya results na why do you nullify the entire result in a constituency Ono ma Afenyo Markin on tiase o make demand to be from the judiciary the high court and of course the NDC government yenko team Afenyo Markin the full video and a press conference onye oyeye kan kese of 1957 news ya me ba and some NDC for eka efa the re-election on ye don say metu jaradi on Nana Janto TV Afenyo Markin.
This judge who knows that when matters close and he's fixed a date for judgment, no matter what, he's supposed to deliver a judgment, decided to stay away from determining the matter because a party has decided belatedly to file a notice of withdrawal of the case. Yet, in a development that defies ordinary legal reasoning, the High Court issued an order directing a full rerun of the entire Kpandai parliamentary election, covering all 152 polling stations to be completed within 30 days. As if this judge is not aware of the Supreme Court decision in the Akufo-Addo and others versus John Dramani Mahama and others in the 2012 presidential petition. The sad part of it is that the NDC candidates and his supporters were aware of the judgment before the day, to the extent that on the day of the said judgment, the regional minister led a team of NDC party faithfuls into the courtroom, anticipating the expected result, the result that they were going to have judgment in their favor. The judge, who spent minutes, walked out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we having now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of courts. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Insawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal, and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that courts occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the vote of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court. Let me emphasize, this is a narrow exception, not a judicial blank check. The Supreme Court made abundantly clear that such power is to be exercised only when, one, the parties have had a full and fair opportunity to address relevant issues, the evidence unequivocally supports the alternative relief, and three, there is no element of surprise, prejudice, or procedural ambush. Now, ladies and gentlemen, none, absolutely none of those conditions exist in this case. The High Court order is not a principled application of the Kojoba doctrine or any other known doctrine. It is a brazen abuse of it, like the judge who invoked the animal farm to remand Abronye. Consider the following facts. One, the petition did not plead irregularities in all 152 polling stations. The petitioner did not lead evidence concerning 152 polling stations. The parties never argued about 152 polling stations. And no one, neither the respondent, nor the Electoral Commission, nor the voters of Kpandai, was put on notice that the entire constituency election was at risk of annihilation. In fact, the key witness to the petitioner underscored the fact that all they needed was a rerun in some 41 polling stations. He again added that the collation was done without due notice to him. Has the judge read the CI? Has the judge listened to the Electoral Commission regarding the violent conduct of the petitioner and his followers, leading to the termination of the collation at Kpandai and eventual transfer of collation to Tamale? Indeed, this is not substantial justice. This is substantial injustice, a textbook case of judicial overreach masquerading as equity. Let me be clear. We do not accept that the petitioner proved this case. But even if he did, the court found credible evidence of wrongdoing. The remedy imposed is still fundamentally flawed. It is whimsical, unlawful, and manifestly unconstitutional. The people of Kpandai. To the people of Kpandai, your Member of Parliament, Honorable Matthew Nyunda, remains the sitting Member of Parliament for the Kpandai constituency. He remains a full Member of Parliament. He remains a proud and active member of the Minority Caucus and the New Patriotic Party. No person, no institution, and certainly no flawed judicial order can suspend the mandate you freely and lawfully conferred upon him, unless and until the appellate process, properly invoked and fully exhausted, runs its lawful course. He will continue to serve you with dedication and dignity. Let me state this emphatically and without equivocation. The minority will lawfully resist any attempt, whether subtle or brazen, to bar him from representing his people. We will not permit democratic legitimacy to be overturned by judicial improvisation. Let the nation hear the Minority Caucus clearly and unequivocally. One, and for the avoidance of doubt and at the risk of being repetitive, Honorable Matthew Nyunda remains a Member of Parliament for Kpandai, and this is not negotiable. He will continue to sit in Parliament to vote, to debate, and to represent his people with full authority. No premature exclusion will be tolerated. We will lawfully and vigorously resist any attempt to remove him before appellate process is properly concluded. We fully support his appeal and his application for stay of execution. The law must run its course, and it must run fairly. Whilst Article 99 makes the Court of Appeal the final arbiter in parliamentary election petition, where a High Court decision is so flagrantly unconstitutional, the minority will not hesitate to support further constitutional litigation before the Supreme Court. When a ruling assaults the Constitution itself, no judge is above scrutiny, and no decision is beyond correction. The Constitution is supreme, and when a ruling violates it, judicial deference yields to constitutional duty. To the good, peaceful, and hardworking people of Kpandai, again I speak to you directly. Your votes matter, your voice matter, your MP remains at post. Do not be discouraged. Do not be shaken. Do not allow this temporary turbulence to diminish your faith in the democratic process you honored with such commitment. You stood in long queues under the sun. You voted peacefully and purposefully. You respected the process from beginning to end. Your loyalty to the Republic will not be betrayed by one reckless judicial act. The law will vindicate the truth, and the truth will vindicate your voice. Justice may sometimes be delayed, but it cannot ultimately be denied. We stand with you, people of Kpandai. We will fight with you, and we will prevail. Although we go through difficult moments, we know the better days of our nation are ahead of us. And to conclude, this judgment is not merely flawed, it is dangerous. It does not advance justice, it obstructs it. It does not uphold constitutionalism, it undermines it. It does not protect the people, it punishes them without cause. His Lordship Justice Bart Planbrew may be a learned jurist and will respect the office he holds. But respect for judicial office does not require silence in the face of judicial error. Quite the contrary, it demands that we speak, that we challenge, that we insist on fidelity to the Constitution and the rule of law. And so we say this with the utmost clarity. As long as the minority caucus stands, this judicial misadventure will not pass quietly into legitimacy. We will challenge it through every lawful avenue available. We will expose its flaws with rigorous legal arguments, and we will defeat it. Not through force. I repeat, not through force, because we have none. Not through intimidation, because we have none. But by law, by constitution, and by truth, we will appeal to the conscience of judges who would want to uphold their judicial oath and be guided by their conscience and their love for country. The soul of our democracy depends on getting this right. The integrity of our electoral system demands it, and the people of Kpandai deserve nothing less. We thank you so much indeed.
For Afenyo Markin, and I will just try and go through. The data. Data for the 2024 parliamentary election. So they see but data them ani which say certain MP your friend Matthew Nyindam ono eye MPP MP Matthew Nyindam ono onya 24,947 votes representing 53.47%. And NDC candidate nisunya Daniel Nsala Wakpal ono enya 24,213 votes representing 46.33%. And do check here vote difference na shada no sir na enchinywa shedu polling stations nimbi ho ana nyasem ketoka nti na ma NDC candidate no honorable Daniel Wakpal edikopiem e wo court Tamale High Court a rule say yes ankoye election for 30 days yankoye election for minority no what omonka misgivings about this particular ruling or judgment. Afenyo Tanko Rashid, Deputy Director in charge of NDC election, when the NDC lawyer, any candidate, Nankasa Mumeche candidate, NDC candidate, Daniel Nsala Wakpal, Omodi, especially Tanko Rashid, or say MPP for Mopa, Mama election because Moba, NDC Bewini. Clear, say or damn your re-election be in this government, actually. In the last 10 months, NDC Nebewini. It's more numbers in parliament, estimated from I think 87 to 86, according to Tanko Rashid. It's a million Tanko Rashid, okay? One NDC parliamentary candidate for Kpandai constituency, Daniel Nsala Wakpal, and Omoloy and some Omoditu Jameba, near Babetwazo.
For having done justice to the good people of Kpandai. All along, the NDC has been saying that there are several crooked electoral officers who are bent on stealing people's mandate. And one of it is what has been exposed today. We said it time and again that the seat of Kpandai was the seat for the NDC. They rigged the election, and we've been saying it time and again that we will continue to expose crooked electoral officers who will continue to rig election. We will stop them. We will make sure that the NDC will prevent such rigging machinery of the then MPP and their crooked collaborators in the Electoral Commission. Clearly, the CI 127, if you look at Regulation 43, 1A up to H, spell out how collation of parliamentary election is done. You collate results based on two forms. We have from 1C and then from 1D. You assemble the results from 1C and then put the summaries on from 1D and declare the results. This was not done. They didn't do that. They just organized themselves, ran to Tamale, cooked some results, and announced Nyindam as a parliamentary candidate elect. This is what they did. And that is why we made sure that we follow through the process. The NDC is the most lawful political party in Ghana. We didn't use lawless means to get this verdict. We made sure that we follow through the process, and we have gotten favorable judgment. I can assure you, we are appealing to our opponents, the MPP. They shouldn't come for the by-election because we will hand them some heavy defeat. if they still want to have some kind of respect to the good people of Ghana, they should chicken out how they chicken out in Tamale Central. Yes. Otherwise, our election machinery, you can see my regional minister is here, my presidential staffer, my candidate is here. We are going home. I'm sending the verdict back to National Secretariat. We are going to prepare. They've given us 30 days. We are ready, even tomorrow. Yeah. We are court.
We are grateful to counsel who assisted. As I introduced them, myself, Counsel Musa Mohammed, we had Eugene Aweti, we had George Adagbaja, and among others. For us, our case before the court was very simple. We had a rogue electoral commission district electoral officer who decided to abuse discretion. Now, what is important, and why this case is significant, is that at every district election collation center, there are certain rights that are preserved for the candidates. Now, when the polling station closes, you move to the district collation center, and that's the parliamentary collation center, and certain things can be done there, including asking for a recount of even the polling station. Now, when you say that there are disturbances at the collation center, the law is clear that you either adjourn it to the next day or you can adjourn it even for a week. But you don't relocate the district or redesignate the collation center without notice to the participating candidates. And then you, when you are brought to court, decide that you are going to support one side against the other, making allegations that the petitioner was involved in busing hooligans to the place to come and destroy property, and also to engage in acts which were inconsistent to the election laws. When the district election officer was put in the box, he could not even point one, even his own videos, to show that indeed the petitioner had done any of those things. So clearly, our point was very simple. The failure to notify the petitioner of the relocation and redesignation of the collation center meant that clearly there was no way he could have participated in the collation and to be able to exercise his rights, which included serious irregularities which we brought to the court. So in the fairness of the entire thing, including the ample evidence that there was complete destruction of the biometric verification system and all that, the only alternative would be to rerun the election. And so we are very happy that the court has ordered that within 30 days the election should be rerun. The power and the sovereignty lies with the people. It is for them to decide who their MP is. And you cannot be a beneficiary of such an incident and call yourself an MP. That is out of the question. So the alleged MP, who has now been clearly exposed as not being the MP elect, was a beneficiary of a rigged system by the district election officer. And I will appeal to the petitioner and the NDC election committee to ensure that that district election officer does not return back to that position, because he can cause mayhem in this country if he's allowed.
Thank you very much. Let me use this opportunity to thank my teaming supporters for supporting me throughout the proceedings. For us, we saw irregularities and we brought it to the court, and the court has ruled. I want to use this opportunity to thank my lawyers. Kudos for the good job they have done. We are prepared to get to the ground, prepare for the election, and at the end of the day, you know what my election director said? We want to set the ball rolling, and the seats will return back to NDC. Thank you. Thank you.
But what these guys are saying, nothing will change. Nothing will change. Nothing will change. We vote. Maybe it's round of who still want them. Nothing will change. If I'm beating you, nothing. Nothing will change. And then the court said we should go and rerun. You have not won any of them. So then we should go back. What shows that you can win? The worst is going to be that maybe because of the incumbency and other things, people will not even have interest in going to vote again. That may be the challenge. Otherwise, we will still beat him, and that will change. So,
enti abusiafo de ekwa kusini no wadi kate minority ninka Afenyo Markin sa enso ana NDC for wati omonka member of parliament for sitting member of parliament Afenyo Matthew Nyendam minimum ade what is his situation. In fact, Afenyo Markin, what is what say, he continues to carry himself as member of parliament for Kpandai constituency. Interesting times ahead. Yadamu nyina asese mo hwe. What you make of the video? Mpacho, leave your comment in the comment section. We are not liking and watching for so anya bi ahwe. News ni dey na doso. Madwuma ne sama betena na mo hu news e trendy. Tie. Na Janto aba no na dwonkyere e dey abre right here on Nana Janto TV Makramo.